The DMCA is a popular topic in the ongoing discussion of censorship and copyright law in the United States, and especially on the American video hosting site YouTube, which this video is hosted on along with Blip.tv in case this video gets taken down. The DMCA is an abbreviation for the Digital Millennium Copyright Act, which was signed into law by President Bill Clinton on October 28, 1998, after a unanimous vote of the United States Senate. The purpose of the DMCA was to bring American copyright law into accordance with two 1996 treaties signed by the World Intellectual Property Organization and make it illegal to create technologies to circumvent the digital rights management technologies which control access to copyrighted material, even if the technology itself is not breaking copyright. The DMCA also made the penalties for breaking copyright on the internet harsher and made it easier for copyright holders to get said material taken down from offending servers. The DMCA also amended Title 17 of the United States Code, which pertains to copyright. This amendment protects Internet Service Providers, or ISPs, from copyright litigation if the users of said ISPs were breaking copyright. The European Union has a similar law called the EU Copyright Directive, but it does not apply to the main YouTube servers as they are located in the borders of the United States and Google being a registered American company which owns the YouTube brand. The DMCA contains 5 titles, which I will outline briefly. Title I brings the United States Code up to speed with the WIPOs and is encompassed in the WIPO Copyright and Performance and Phonograms Treaties Implementation Act. The second portion of Title I outlines the anti-circumvention laws which require that all analog video recorders have support for a specific form of copy prevention commonly known as macrovision built in. This effectively gives Macrovision a monopoly on the analog video recording copy prevention market, but this is a topic for another video. Title II brings the Online Copyright Infringement Liability Limitation Act into effect. This act protects ISPs from liability if their users are filed against under the DMCA, but only if they adhere to the DMCA by promptly blocking access to the content in question. This is commonly shown on YouTube when a DMCA claim is filed and the video is immediately blocked to ensure YouTube is not liable for the content which could be breaking copyright laws. Title III ensures that those repairing computers can make temporary copies of files or content while repairing computers so that no files may be lost or damaged in the repairs. Title IV includes assorted provisions such as clarifying and adding duties to the Copyright Office, adding provisions to assist libraries with keeping copies of sound recordings, and more provisions relating to collective bargaining and the transfer of movie rights. Title V ensures copyright protection for certain designs and protection of original designs such as boat hulls. Before, they were not considered protected because they could not be separated from their function. See, people, this is why we need to read our laws. They're insanely fascinating. Now, the text does not seem that controversial, but 2 have sprung up in connection with the DMCA. One pertains to the anti-circumvention monopoly created by this act and the commercial organization Macrovision, but this does not pertain to the current YouTube argument on censorship, but I would like to revisit this at a later date. The act which pertains to this is in Title II, which outlines the Online Copyright Infringement Liability Limitation Act. Because of this act, YouTube has streamlined the DMCA claim filing so they are not liable for the breaches of copyright on their site. This came to the forefront when on March 13, 2007, Viacom sued Google, the corporate parent of YouTube, for $1 billion in damages due to YouTube's users uploading material owned by Viacom to the site. The lawsuit is still pending and is not expected to go to trial until later this year or 2010. A judgment was handed down on March 11, 2008 that Viacom cannot seek punitive damages, but will still seek large statutory damages. Veo suffered a similar lawsuit from the I.O. Group. The lawsuit was filed on June 23, 2006, with I.O. claiming that the conversion software on the site renders the safe harbor created by the DMCA moot. The lawsuit was settled in Veo's favor as they were in compliance with the DMCA and were protected under Title II. Filing a DMCA on YouTube is a simple process, as per DMCA Section 512 states that the service provider is not liable if a user posts or uploads material that contains copyright and is taken down when a notice is received. A takedown notice can be sent to YouTube by copyright holders who wish a video taken down or certain accesses blocked. Unfortunately, the relative ease of filing a DMCA 512 claim has led to the abuse by people who don't want others' opinions heard or their works used for criticism. Fair use is not defined in the U.S. copyright laws and is based on a case-to-case basis, but fair use can be determined by a 4-step process defined in U.S. Code Title 17, Chapter 1, Section 107. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. 4. The effect of the use upon the potential market for or value of the copyright work. While the YouTube Terms of Service and Community Guidelines states that you should not upload others' content, and in fact the TOS forbids downloading videos from the site unless the site lets you, YouTube has not banned others for doing this before and seems to have forgotten about this provision. The opinion of this video maker is that using others' videos for legitimate criticism is fair use, but it is technically against the YouTube TOS. Due to this, filing a DMCA against a video that uses your video goes against the law. The correct action, based on all legal research, is to contact YouTube or to flag due to DOS violation. This video maker does not support this action, though. Using the DMCA to silence critics of your video is a cowardly act, and also against the law. Fair use is still in effect, but if you wish to have the video taken down legally, the only way to do that is to go through YouTube, as it does violate the terms of service and can result in your account being suspended. As to that fact, I, the administrator of the DM and Colon channel, released this video into the public domain. I encourage everyone who wishes to upload this video to do so at no legal penalty toward themselves or their organization. All information in this video can be found on the sidebar and includes full text of the DMCA and copyright code from the Library of Congress at Cornell University's Legal Information Institute. I support free speech and fair use. For more information on the DMCA, follow the link to the Electronic Frontier Foundation on the sidebar. Support fair use. Support free speech.